Thank you, ma'am. All righty. Welcome to the House Judiciary Committee. I would say it's the last one of the year, but not around here. Never know. If you would, please bow your heads with me and we'll begin with a word of prayer as we always do. Lord, we thank you for the opportunity to come here and meet as the House Judiciary Committee as we always do. We thank you for all the blessings we have as a state. We ask you now to give us wisdom as we consider bills for this legislative process. Amen. All righty. Let's see. All right, let's deal with Senate Bill 38. I think you have a sub in your folder. The Senator Ligon is probably in Senate Rules with about half the House. So the underlying bill deals with, can you speak to the underlying bill, Mr. Welch? Okay, because you have language in there too that I want you to discuss. If you can speak to the underlying bill and then your language, and then we will also fill in the blanks on the underlying bill if you need us to. Representative Welch.
Thank you, Mr. Chairman. So Senator Ligon's bill dealt with e-filing and dealing with the service charge associated with e-filing. So you'll see that in section, on page 2 of the bill, you'll see that the e-filing rates we've already have set in code, but there's also an exception that's been carved out for the fee for governmental entities, because that money is obviously just going to be recycled back through the system. And that's on lines 37 through 45, and then it's renumbered from there. We still allow for pauper's affidavit and validations of bonds. The e-filing costs will not apply to those. So you'll see that that language at the bottom of the page and rolling over at 61 and 64. Then we struck the effective dates because there was an opportunity for courts to use their own administrative rules, and that line 79 through 80. That's been stricken, obviously, because we're codifying it here in this statute. Also, we added some language at line 39 and 90. This deals with post-judgment proceedings, just to clarify when that applies, and to put in a 30-day rule there. And then you'll see at lines the assignment of a new case number that is dealt with at lines 101 through 103. And then we pick it back up with Title 15, so we've dealt with it in Title 15 there at the beginning, but then we pick it back up at Title 15, Section 7.5, and we've also dealing with those filing fees again in Section 1-4, and you'll see the same exemptions at line 121 through 129. And then you'll see again the restatement of the filing fees are not applicable for pauper's affidavits and pleadings that are under seal. You'll see that at lines 140 through 146. Then at lines 147 through 150, you'll see the additional language of, that you can still physically file by an attorney or his designee at the courthouse. Interestingly, Representative Estration and I were talking about earlier about having some kind of, eventually maybe in the future, having some kind of system or a station that you could actually do an electronic filing there. And that may be something we consider in the future. We had debated that. You'll probably remember, Mr. Chairman, a couple of years ago, we debated whether or not to have those a computer system there, so you could scan in your documents yourself and do an online filing there. Again, we struck the previous language about the effective date at line 161 through 163, and then we also required the electronic service of pleadings in section Part 2, Section 2-1, and that concludes the underlying bill for Senator Ligon. with respect to the
Let's,
additional
let's,
part of-
let's do this. Any questions on that portion that Mr. Welch has already covered? Okay, go ahead.
on part 3, we've added in what is House Bill 502. This is specifically includes the language that deals with legislative leave. You'll see that on pages 7. And then again, it picks up again the substance of the language at page 8 at the bottom of 3-3. You'll see it's applied legislative leave is being amended. And in this case, dealing with the Civil Practice Act, legislative leave has incorporated the language from the study committee that the Speaker appointed to deal with the issue of legislative leave and look at what amendments in the law should be considered by the General Assembly. A former representative and former majority whip Edward Lindsay is here. Senator, we took care of your first part of your bill, so yes, sir. But I'm sure you took care of my bills and rules, right? So on the
one second,
yeah.
Mr. Welch. Senator, Mr. Welch went through your portion of the bill, and I'm trying to think if there were any changes that you didn't already know about that we hadn't discussed with him previously. Yeah. So the underlying portion of the bill is there. I mean, I think we made we reworded how municipal corporations and counties are exempt, but I don't. And then the Chief Justice had that one portion he wanted about making sure once you gave your email for electronic filing, you couldn't withdraw it, and I think that's the only changes there. Is that right?
Correct. No changes to the leave of absence. So
No.
if you don't need me for anything else, I can go back up to rules.
As long as you promise to move House bills.
And we'll do what we can. In fact, I'm asking for a House bill.
You get out of here
for a
then.
member of the House.
Thank you, Senator.
Mr.
We
Chairman.
appreciate you being here. Sorry, Mr.
Thanks,
Welch.
Senator.
Please continue.
No, thank you, Senator. And so the study committee was formed to look at that issue as a bipartisan commission, and Mr. Lindsay is here, so I will let him explain to you what the committee came up with. But in essence, we have inserted the language that the committee recommended into this bill, into the underlying Senate bill. That bill is equivalent language is also pending in House Bill 502. That is pending in Senate rules. And with that, I'll let Mr. Lindsay come and explain what the commission recommended. And then there were 2 or 3 changes that I have discussed with him that we have made to this bill I want to make the committee aware of.
Mr. Lindsay, you want to come forward, please, sir? Good to have you.
Thank you, Mr. Chairman.
Thanks for coming today. Have you ever been in this room before?
I've been in this room on many occasions. I was going to tell you how glad.
Did they
that
change your bills when you were in this room?
Yes, it did.
Okay.
There's
all
no
right.
reason not to change it more.
All right.
I was going to say it was great to be back until I saw Judge Stevens in the back, and I suddenly had post-traumatic stress disorder.
Well, we hadn't recognized our judges yet, but we'll talk about them and then recognize them in a minute. So please continue. Yeah.
In all candor, Judge Stevens is a very good friend and damn fine trial judge. And I will say that he's an activist judge because he always seemed to act against my clients. I did, let me, in all seriousness, this advisory group took on a very serious task that was requested by the House Speaker in light of some of the information that's come to light, the news articles, as well as his talk on the floor of the House. Just very briefly, if I may, Mr. Chairman, sort of talk about my advisory group. It was a bipartisan group. It included, for instance, both the minority and majority leader in the House, as well as 3 judges, a trial judge, a Court of Appeals judge, and a Supreme Court judge. It included prosecutors and criminal law defense attorneys. It included plaintiffs' lawyers and insurance defense lawyers. So it was a very well-rounded bipartisan group. We took a hard look at some of the allegations that we'd seen that had come out in the newspapers, and listened to a lot of the concerns that had been raised by folks who had had cases up in that particular area. We also drew from our own personal experience in the courtroom, and also, more importantly, pulled, or equally importantly, pulled from statutes around the country, and tried to figure out what would be the best practice in terms of what we were moving forward. We operated very much from the principle that I've heard when I first got here a long time ago, which was we don't chisel laws in stone anymore. We put them on paper because there's always room for improvement, and that's what we were looking to do here. We were guided in our discussions by several factors that I think are important to remember when it comes to a lawyer-legislator. A lawyer-legislator is the only entity in the General Assembly that also has a duty to another branch of government, and that's the Judiciary branch of government, both in terms of representing their clients' zealotry, as defined, zealously rather, as defined by the uniform model of our rules and ethics requirements, but also has even a higher duty than our clients is our duty as officers of the court to make sure that the judicial system is moving forward properly. We wanted to take a look in light of that at certain duties that are mandatory for a legislator to make sure that the lawyer-legislator is fulfilling his or her duties to their constituents. And that would include, obviously, the time period shortly before the General Assembly starts, the time period during the General Assembly, both special and regular, as well as the time period shortly thereafter, and called committee hearings that they were required to attend. In addition to that, we recognized, as well as other states have recognized, that in this modern day, legislators do have certain duties outside the General Assembly regarding their duties to their constituents, and we wanted to allow for legislators to be able to request leave, but we wanted to make sure that the judges remained in control of that process. And so we required, first off, within the bill, that a legislator requesting leave must first and foremost be the lead counsel in the case, and must state with particularity. And for those of this committee is made up of lawyers, so you understand that that has a particular term of art within the law in terms of giving specific reasons why you need to request that leave. And in addition to that, we wanted to make sure that folks on the other side had an opportunity to object, and that includes both the parties on the other side in civil cases, as well as the judge him or herself, and also in criminal cases, not only the prosecutors would have a right to object, but the victims themselves would have a right to object. And we also wanted to lay out specific grounds that we felt were important for the judge to consider in determining whether to grant that leave over an objection, which would include the time in which the case has been pending, what a legislative leave would encumber the case in terms of what kind of delay would be created, the respective rights of the parties that would be otherwise impacted. Those were all things that we took into account. There has been one question that was raised to me, I think, the other day by a legislator that I think is important to let you and anyone else who is concerned about this issue. Why not simply take out this portion of the bill and simply just go with what the old law was? And the answer is simple. There's already within both the uniform state and Superior Court rules the ability to grant leave. We felt that given the heightened political scrutiny that a lawyer legislator has, when they request a leave as part of their official duties, that they have to go through extra hoops, which is what this law does, and also sets out exactly what a judge will consider and whether or not to grant that. So that's why we decided it was important enough to put in the law and not simply just punt it back to the uniform rules. That, in essence, is what we came up with, and I'll be happy, Mr. Chairman, to answer any questions.
And we appreciate your work on this issue for us. Questions of either Chairman Welch or Mr. Lindsay. Number 5, Mr. Walensky, is that you? Okay.
Thank you, Chairman. I do catastrophic injury, and I've never seen this done before, so I'm just wondering. Here it says the court on its own motion can make a motion. Is that happen in other areas of law?
Yeah, I mean,
yeah,
a court
okay.
a court can, in many cases, when a party requests something, can on their own object to it and take a closer look to it, even if an opposing side does not.
Then we call it sui sponte, don't we?
Yes, I believe that's the Latin term.
Okay. Mr. Is that Ms. Silcox? Ms. Silcox.
Thank you, Mr. Chairman. It's my understanding that this bill was reviewed, as you mentioned, by a bipartisan group, and it was approved by the Special Judiciary in the Senate.
Yes. And let me emphasize, I didn't say it earlier, this was a unanimous decision by my bipartisan group.
Thank you.
We, like I said, I gave them some pretty intense homework assignments, and they all came back looking at it closely, and it was a good discussion.
Thank you for your work.
It was also a unanimous decision by the Special Judy Committee
Yes.
in the Senate.
Thank you.
Do you want me to point out any of the slight modifications?
Go ahead. It'd be a good time to do that.
So if you look at,
And these are the modifications since the Special Judiciary Committee in the Senate passed
I'm
it.
only going to point out the modifications that I've recommended that we consider, and I also think the Senate will consider as well. Line 201 through 203, you'll see the language there that says any member of the Office of Legislative Counsel or their staff. Remember, Office of Legislative Counsel, including the Legislative Counsel and the persons provided for under subsection D, Code Section 28-4-3. That's referencing anyone that is hired by the Office of Legislative Counsel, appearing on behalf of the General Assembly in a case. That would allow for our members of Office of Legislative Counsel to, while we're in session, not be called into court. We need them here writing bills. That's their primary function. But they do defend the General Assembly against litigation that may be filed. So they are from time to time in court. In fact, there's, I think, a pending U.S. Supreme Court. Now, this obviously wouldn't have any control over the U.S. Supreme Court, but it would have control over state court, over the state courts. In addition to that change, and that change is made both at those lines and then also at line at line 266 through 268. The same language is inserted there in both places. So it'll be mirror image in both Title 17 and Title 9. If you'll look at line 232, where it begins opposing counsel, this is when we're not in session, and this is who can object to a continuance being granted. It says opposing counsel, and then the change in the language is a party to the case. It used to say an interested party. That was overly broad and it was undefinable. So we decided to go with a party to the case. That would be an individual that would have the right to object to any of the proceedings. So in a civil action, that's the nature of that, a party to the case. And then the last change that I recommend is at line
300.
299. You'll see there it begins opposing counsel again, and the recommended language from the committee was again an interested party. We specified that it would be any party who is alleged in the case by the state to be a victim, and therefore we're elevating the rights of victims to interject in the seeking of a continuance. And you'll note again, former Representative Lindsay here had pointed out that the language says that the motion for the continuance must be a certificate filed with the court that states with particularity what the reasons are, what the legislative duties are that we're called upon to take action on. and that must be filed as a certification with the court. So I just want to emphasize those things, and you'll see the standards by which the court is to review that request if the motion is contested. If the motion for continuance is not contested, it's granted. And you see that lines 306 through 312, those underlying issues that should be considered by the court. Number one of which is the length of time that a case has been pending. That is the same language in both the Title 17 amendment as well as the Title 9 amendment. And those were the only changes, Mr. Chairman, that we deviated from with respect to the committee's recommendation.
Other questions for Chairman Welch or Mr. Lindsay? Mr. Lindsay, won't you just stay right there in case we have other questions that do pop up, if you
Okay.
don't mind.
Happy
Mr.
to.
Turner? Yeah, please.
Goodbye. It wouldn't be a legislative session if I didn't get to come see my favorite committee. Thank you for this last-minute opportunity to make that happen. First, I want to start off by thanking Ed, Lindsay, and his team of folks for these sets of recommendations. And I will tell you, if this comes to the floor as is, I will vote for it because I think it's better than what we have today. That being said, I don't think it fixes the problem of abuse in what we've seen. And what I mean by that is this term that we're going to become very familiar with over the next several days in debating this when it gets to the floor is this concept of lawyer-legislator. Only one person has abused this as it is today that we know of, and research is being done for everybody who's an attorney in the legislature. There are media people who are very hungry to find a story, and it's not just about the speaker. So if there are abuses of this, it's going to come to light over the next several months. That being said, what we know today is that one person is abusing this process, and that's the speaker. The speaker isn't a lawyer, but he's a speaker lawyer, a speaker legislator lawyer. That's a different category than just a legislator lawyer. We all know what kind of power and authority come with the position of speaker. It's an incredibly powerful position in our body. The purse strings of the budget are held very tightly. We go through this process of the budget, but we know ultimately decisions can be made at a very high level that affect a very low granular level of the budget. I have taken the time to speak with prosecutors in the Onoda Circuit, retired legislators from the Appalachian Circuit. There is a sense that their hands are tied. I think to a large degree this will deal with that if somebody's just a regular legislator attorney. But we're talking about one of the most powerful people in our state. And therefore, I have dropped a separate piece of legislation. I was not prepared today with any type of substitute language or an amendment for you all to consider. But I would like for you to consider, even if it's into next year, making the position of Speaker of the House a permanent full-time position with 100% of their efforts pointed towards that role. And I think that eliminates, and we could do something creative. We could bump the compensation for that to accommodate the fact that this is a full-time role. We expect 100% of their effort to be put into that, and it removes the conflicts. We no longer will have these stories that we're going to continue to hear about this summer where victims have been denied justice. There will be no undue influence to the budget for the judicial branch. There will be no intimidation. It'll eliminate those conflicts, and that's really what I'd like to put before you as committee members as something to consider. I know it might be too late to add this to this bill, but it is something that I think needs to be explored. And I thank you for your time and effort on this matter.
Questions for Representative Turner? Is that Ms. Oliver? Okay.
I think the governor is a full-time position but operates other businesses in my political life. That's been true. So are you only just looking at somebody who's more powerful than the speaker, the governor? You're suggesting that only a lawyer, state constitutional officer, should be barred from having a second job, or anybody?
No. If you wanted to look at some sample language, I went to Legislative Council and I asked about the three most powerful people in our state, which most people would agree are the Speaker, the Lieutenant Governor, and the Governor. And I asked for them all to be included. Legislative Council did not include the Governor in the draft legislation of HB 675, but did include the Lieutenant Governor. So I would agree that there are conflicts there as well, but we're not talking about somebody who's just an attorney. You could be a plumber, and if you became speaker, you would become speaker for full-time for the duration of your term.
But we have a lot of examples of the governor and the lieutenant governor having other jobs, and you want to eliminate that for them, is your proposal, as well as the speaker's position, whether they're a lawyer or not.
That's correct.
Okay. Other questions of Mr. Turner? Thank you for being here today.
Thank you. I appreciate the committee's time and effort. Thank you. I appreciate
Okay.
you.
Thank you.
All right. The bill is now back in the breast of the committee. Is there a motion? Well, is there a motion? Is that Ms. Silcox?
I make a motion we do pass.
Is there a second? There's a motion and a second. Is there discussion? Hearing none, all those in favor of passage of SB 38 by committee substitute, please indicate by saying aye. Aye. Any opposed? The bill moves on to rules. All right. Senate Bill 31, Senator Rhett, see here. Come on up, sir. You don't mind if I go to you? No. Senator, good to have you today. Please tell us about Senate Bill 31. Okay, no problem. Okay.
Thank you, Mr. Chairman, fellow representatives, colleagues, friends, and y'all. I'm here today with my friend and the person who helped me to craft this bill, Frank Rotundo. Frank, you want to introduce yourself?
Senator, hold on one second, if you might. The chair failed to do something I intended to do in between bills. As was mentioned earlier, we do have 3 of our Superior Court judges, I believe, that are here with us today, and they're all sitting next to each other. Are y'all allowed to sit next to each other? Okay, sometimes. All right. You look like a 3-judge panel. All right. Okay. We have Judge Guy. Good to see you again. And Judge Stevens is who was referenced earlier in, I think, a positive light. And Judge Gosselin, we appreciate y'all being with us today. Thank you very much. Senator, I apologize.
No problem, Mr.
We
Chairman.
lawyers always like to recognize judges whenever possible. So,
I understand.
Okay, good. Good to have you.
Thank you, sir.
Go ahead.
I'm here with Frank Rotundo. Frank, you want to introduce yourself? He helped me to craft the bill.
My name is Frank Vincent Rotundo, and I'm the Executive Director of the Georgia Association of Chiefs of Police.
Frank, thanks for being here today. Good to see you again.
Basically, this bill would provide civil immunity for law enforcement officers for the rescue of people or pets trapped in motor vehicles when there is a clear and imminent danger or threat to the person's or pet's life or health. It revises statutory provision regarding limitation on liability for law enforcement officers performing duties at the scene of an emergency to add a definition for the term emergency, which includes the rescuing of person or pets from a locked vehicle, and it also defines the term pet. This bill adds the definition of emergency for law enforcement that includes the rescuing of a person or pet out of a locked vehicle. This bill defines pet as a domesticated animal normally maintained in or near the household of its owner. Basically, this is law without having to go into litigation that supports the police rescue action and as defined emergency. It made it through Senate, the Senate committee unanimously, the Senate unanimously, and then the House Judiciary Committee gave it a good scrubbing. And now I'm here to answer any questions and ask for your favorable support.
So, Senator, let me understand. You're helping police officers and dogs at the same time. Is that right?
Yes, sir.
Because I don't think helping dogs is just enough. We're going to need a little more here. So maybe we have a We Like Puppies caucus in the House, but it's not as big as it needs to be. So I'm hoping we can expand it with your bill today. So questions of our senator or Frank Rotundo? Did I pronounce that right, Frank?
Yes, sir.
I usually just say Frank. Okay. Any questions? Mr. Whip.
We are saying just a locked vehicle, not any trailers or anything like that. It's purely a locked vehicle, like the language we've seen kind of before, right?
Yes, yes, sir, Mr. Whip.
Thank you.
All right. Other questions of our senator or his witness? All right. We do have one person signed up to speak on the bill, Senator. So, Frank, maybe if you could just move over one chair, I'll ask Deborah Berger. Deborah, welcome. Good to see you today. Please come up and introduce yourself and tell us who you're with, and we'd be happy to hear from you. Senator, you can stay there.
Just being a gentleman.
No, I got you. I understand. I thought you were moving. Thank you.
Hi, my name is Deborah Berger, and I'm the state director here in Georgia for the Humane Society of the United States. And on behalf of our members and supporters, I want to thank you for considering this bill. And at the Humane Society of the United States, in particular in our animal rescue team and our disaster response, as well as our animal cruelty team, we are privileged to work with the brave men and women who dedicate their lives to making our communities safer. And in times of crisis, law enforcement officers run towards danger in the hopes of protecting us from harm. And SB 31 will return the favor, ensuring that law enforcement officers are not liable for actions taken while performing a duty at the scene of an emergency. So we would respectfully urge this committee members to support SB 31 as it protects Georgia's law enforcement in their work to protect us. And I'm happy to answer questions. And at the subcommittee, y'all heard from Dr. Dorsey, and she gave you some of the physical issues that would be that somebody trying to save an animal from a trapped car or would run into. So I don't know if you want to go through all that again. We just feel like this is an excellent bill. That
Well,
covers.
we got a few questions, so
Okay.
we'll see how we'll go from there. I think a member of the Pro Puppy Caucus, Mr. Walensky, wants to ask you a question.
I'll start with my
You
two.
are in the Pro Puppy Caucus,
Yeah,
right?
thank you, Chairman.
Okay.
I'm going to speak 2 minutes on why I am pro puppy. I had a dog. I love dogs. Okay. No, I'm wondering is, yes, that is all. No, on, just want that on the record. On line 17, it reads that the emergency is imminent danger or threat to life, health, or property. And I'm just wondering why we have property here if.
Is it that the dog would be considered property?
Yes, that's what legal counsel decided when they put it in
the
there.
life is only to the human. The property would be to the dog.
In Georgia, animals are property.
So, imminent danger or threat to the property.
Yeah, the life of the dog, so to speak, would be imminent danger to property.
But would it be life of the property then? Am I reading?
No,
Okay.
imminent danger to property. I think would cover it, but
That's good.
that's open
All
for
right.
discussion.
Thank you, Chairman.
Yeah. Okay, Mr. Whip.
Thank you, Mr. Chairman. I'm just trying to think about the debate we've had on this issue. I'm trying to answer maybe some of the concerns we had earlier in the week. I'm almost wondering if to tighten it up, it needs to be something besides just a law enforcement officer, and it needs maybe have something about while they're actually on their shift or while they're in their uniform or something like that.
Mr. Reed is with the Pro Puppy people. He wants to respond.
So we've had a lot of similar bills this year, and I think there might be some confusion as to what this one just actually does. It only affects law enforcement officers, and it goes to their immunity from being sued while working the scope of their duty at an emergency, and it merely uses the puppy by way of example. This has nothing to do with any of the other bills. This is only for an officer who's going to be immune from suit, except for wanton and willful conduct while acting at an emergency. What is an emergency? And it provides the puppy as an example of what an emergency is.
And human.
Well, and humans.
It's current law.
Yeah, if you look what is struck on starting on line 30 through 34, I think what we're doing is using the pet specifically as it made reference to property. We're naming that pet or person on line 18.
So they're at the scene of the emergency. That may
Yeah,
clear it up
you
for
got to
me.
be a police officer. It's got
Gotta
to be an
at
emergency, and you got to be performing your duties.
Okay.
And I think a police officer, whether he's on duty, quote unquote, or off duty, is still going to perform his duties. And the judge behind you shaking her head, and judges are always right.
I
Yeah,
agree with
yeah.
you. I agree with you. As are the chairman. I appreciate that.
Yeah, but chairman can be overruled by a vote. Judges can't. So, all right. Thank you, Mr. Whip. Let's see. Do we have anyone else with questions of our witnesses? Okay. All right. Thank you all for being here today, Senator. We appreciate it. Is there a motion regarding the substitute to Senate Bill 31? Well, what kind of dog is it? Tell us. And the name. Henry. Okay, I like that already. Yeah, do pass. Is there a second? Mr. Chairman of the Rules, were you going to show us a picture of your dog? I've got a grandbaby. Well, that's even better. You win. All right, there's a motion and a second, I believe I heard. Any further discussion? Hearing none, all those in favor of passage by substitute Senate Bill 31, please indicate by saying aye. Aye. Any opposed? Have 100% pro-puppy caucus in here. Thank you, Senator. We appreciate you being with us. And we will stand adjourned.